goods. The bill is also lacking in conformity assessment procedures and other provisions to ensure that it's not used as a technical barrier to trade, a disguised restriction on trade, a trade restrictive measure, or a trade distortive measure. And we can improve Bill C6 if there's a clear statement that the bill will be interpreted consistently with Canada's international obligations. We don't have that in the bill, and what's ironic is we required through negotiation with the Americans to have a similar provision in their Buy America legislation, that the Buy America legislation would not be used for bad protectionism. So we actually have a precedent that we can borrow from our friends to the south. If the bill included clear rules on what factors will go into the determination of whether a good is a danger to human health and safety, if we can have clear rules about advance approvals that can be obtained to control business risk, such as advance rulings, with clear procedures for appeal, because then we might encourage some of our business partners to come forward and actually work with us so that we reduce the likelihood of dangerous goods entering into Canada. And could we have provisions to deal with when goods are an imminent threat, where immediate action is required, such as the melamine case out of China, and where there's a concern, but a more detailed process and lengthy process should be available. Problem number 2 is when I look at the international obligations, I look at paragraph 3 of the preamble, which states, whereas the Parliament of Canada wishes to foster cooperation with the Government of Canada, between governments in this country, and with foreign governments, and by international organizations, in particular by sharing information, I don't see any provisions in the bill to do that. And in fact, given the strictness of the provisions that my friend was talking about, foreign governments may be reluctant to share information with us because they don't want to disadvantage their businesses who have market access into the Canadian market. And as we can see by a number of WTO cases, importation bans are very seriously taken by foreign governments. It's also worth pointing out that 2 executives involved in the milk scandal in China were executed yesterday. Other countries have a different view on consumer protection and the penalties for consumer protection. And does this bill put us in a place where we may be in an uncomfortable position in sharing information? And I just point that out in passing. Problem number 3 is the requirement to provide any and all documents and disclosure. And Section 38 establishes criminal consequences for infraction, and other provisions allow inspectors to go and obtain any document. Paragraph 20 sub 2 sub c permits an inspector to examine any document and take copies. And so it doesn't exclude legal opinions. It doesn't exclude anything that may be subject to solicitor-client privilege, but it also doesn't exclude technical intellectual property documents, secrets that that companies don't want to get into the public realm. And should they be required to get a court order, should the Canadian government be required to get a court order in order to get these sorts of documents and have the opportunity to prevent the disclosure of these documents? The requirement to provide any and all documents raises concerns of company secrets getting in the wrong hands. And what if the shoe was on the other foot and it was China or Nigeria or someone else who was going to be able to get Canadian businesses' secret documents, their intellectual property, and if the shoe was on the other foot, would we be concerned that maybe someone may be using Canadian secrets to infringe Canadian intellectual property rights? And we need to be concerned about that, because I've actually had a recent case coming out of China on behalf of a client where the Chinese customs seized goods leaving China and allowed the person making the complaint to go in and look at all the documents, take photocopies, and then file patents to contradict the Canadian exporters' rights. And so things happen around the world. We learn from these experiences, so I can see the potential for some mischief in this bill. Sections 15 and 16 grant the minister the right to disclose personal information and confidential business information without the consent of the manufacturer, importer, etc. Section 17 goes even farther and allows the minister to disclose confidential business information to the public where there's a serious and imminent danger. The question is whether alerting the public would require the disclosure of any type of confidential business information. When you look at the definition of confidential business information, it seems to go beyond what is necessary to alert someone to a danger and the secrets of the business. Time frames. The time frames for reporting incidents is short and may not be realistic in the corporate or international context. For example, subsection 14 sub 2 requires reporting of incidents within 2 days, and section 14 sub 3 in 10 days. By putting the number of days in a statute, you're setting up good corporate citizens to fail. And generally under international law, reporting requirements need to be reasonable, and sometimes translations need to take place. You've got time zones. I'm not really sure whether or not this is going to work. The last point is there doesn't appear to be a due diligence provision that as Mr. Buckley said, but also if this is about consumer protection, shouldn't we have a due diligence provision that says come forward, act in a duly diligent manner. If you do that, we understand mistakes can be made. Someone can have all of the best intentions, and then afterwards, we come out into some additional information. So if you have a due diligence defense and have a due diligence process, wouldn't we encourage foreign businesses to comply, to come forward and work up front so nothing bad happens at the end of the day? Shouldn't we have that as part of this bill? And it will allow our trading partners to understand Canadian law, understand Canadians' needs, understand Canadian concerns and procedures. And I would be happy to answer any questions that you have.
Well, thank you very much, and thanks to both of you for your opening comments. We'll get into questions now. I'll start off with a couple and then go to the table for my colleagues. Mr. Buckley, in both cases, I'm going to tell you what Health Canada officials have told us, and I'd like you to respond to it. You talk about the precedent. Health Canada officials say that the powers outlined in this legislation are similar to other pieces of legislation, such as the Canadian Environmental Protection Act, the Pest Control Products Act, the Canadian Labour Code, the Controlled Drugs and Substances Act, and the Health of Animals Act. You also talk about the law of trespass being abolished by Bill C-6. They say no. They say that the inspectors, quote, the inspectors are only permitted to pass over or enter a private property for carrying out their duties under the law, end of quote. So could you comment on both the trespass part of this and the precedent in view of these other pieces of legislation?
Certainly, I'd be glad to. And maybe I'll start with the trespass one first. I mean, I think that we're not expecting Health Canada inspectors on their off time to decide to wander onto people's property. So I do take it as a given that they'll be, exercising their duties under the Act, as broad as those are. I don't know that that is any consolation to Canadians that Health Canada inspectors can't go into their house without a warrant, but could go onto their private property. I don't read this as limiting them from staying out of your outbuildings. They can certainly go into your commercial premises, but I'm most concerned just about the private property as far as residential property aspect of it. It's no consolation that they might be actually investigating you or your neighbor. It's exempting them from the law of trespass. And so it just raises the question, if I am carrying out a business in my home, they have the right under the Act to come to my house and ask if I'll let them in to inspect the home. And if I won't, they have the right to go and apply for a warrant under the Act, to get a warrant to, I'm assuming it would just be restricted to verifying compliance with the Act. That's actually very common. It's that those types of provisions are in our current Food and Drug Act, for example, another piece of legislation that they administer. But that's different than exempting inspectors from the law of trespass. It is a precedent. I'm not familiar with the Environmental Protection Act. In fact, of the acts that you read through, the only one I'm familiar with is the Controlled Drugs and Substances Act, which is a criminal law act which certainly does not allow the police